Hey, right, everyone. Good evening. Just bear with me a sec whilst I do the usual bits and pieces here. So, welcome to the regulars. Say hello if you want to. Be nice to hear who's here tonight. As always, please don't share personal data in the chat. Just ask a question as if it's about a hypothetical person. So, what if someone was in this situation? Blah 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 blah. That's going to get you the same answer to the question that you want, but it doesn't involve you having to put your personal data on the internet or, in fact, anyone else in your family or anything like that. So, what else I've got to do? Done that. Hey, you right, Mary? Let's pin that for a second. So yeah, and then let me put this in bold as well. What's the other thing? Oh yeah, so we're not legal advice as always. So we're just doing our best here to be helpful. We will try to reference the law where we can. Obviously, it's not always possible, and I guess it's always going to be that the questions will sometimes get lost in translation a little bit. So we'll do our best to unpick it. But yeah, it's just the nature of what we're doing, I guess. Right, cool. So, and as always as well, a number of questions are coming through the week, which are anonymised. We'll do them first. Then we get into the live stream in terms of the questions that have been asked there, provided they're anonymized. And then in fact, I think this week no one's asked a question in the first person, which is useful. Yeah. Yeah. I think everyone's good. Yeah. Cool. So, um, I haven't got any gossip this week. I did see that there was another LGO decision today involving a council or council advising a tenant that they should stay until the bailiff comes. It was actually to the landlord. The landlord ended up getting £1,000 because the council advised their tenant to stay put. Not a lot of detail on it, unfortunately, because technically it wasn't upheld because the council had already offered £1,000, which the LGO couldn't add to. So, but I can tell you which one it was in a minute, which council it was. But yeah, if you're not already subscribed to the LGO newsletter, I suggest you do that because it's just a really good source of information, basically. But other than that, have you guys got any interesting stuff happening at all, Shannon?
Well, I'm always worried about saying it's interesting. I feel like that's a high threshold. But there were some stats sort of found and like a report done by the government I was reading up today. And I'm not gonna lie, it's a long document. So I got ChatGPT to like analyze the stats side. Um, but it's all about repeat homelessness is like way more common than previously thought. So 16% of homeless households experience repeat homelessness. Prison leavers are at 37% higher. Like that's, yeah. Supported housing evictions. So 12% of repeat homeless households have been evicted from supported housing compared to 3% of first time homeless households. Again, people in TA. So 40% of repeat homeless households were placed in temporary accommodation compared to 33% of first time ones. And I just thought it's interesting actually because it shows to me anyway, it really highlighted like the system's not working and the suitability of accommodation, which I know comes up on the live stream like a lot. It's clear that the councils are placing people in unsuitable accommodation. There's no, surprise that they're coming back around the system. Um, and so yeah, maybe not interesting to everyone. And I'm sure the whole document is perhaps a bit more interesting than those sort of highlights, but it's no surprise either that like one of the recommendations I think was around working out those gaps of like vulnerable people and like particularly prison leavers, hospital leavers, people in supported accommodation. And again, I sort of want to look into the supported accommodation stats a bit more because I think it might show that cycle of homelessness. And I'm not sure the time period of the repeatedness, whether it's like 5 years or 2 years or what have you. But yeah, that's what I was reading today. Not quite interesting, but
No,
interesting
that's
to
cool.
some.
Can you send the link into the Zoom chat and I'll put it into
Yeah, I'll dig it
live
out.
stream chat, just for anyone interested. Hey, you are Ali? You are Stella? You are B Smith? And Aqua Gyal. Am I saying that right? Hopefully, I'm not embarrassing myself. I was doing training yesterday in Erewash, which is a district I didn't never heard of before, really, up in I think Nottinghamshire. And I spent the first half of the training calling it Earwash until I questioned it and I said, "Is that how we say it, guys?" They don't know. It's definitely Erewash. So anyway, but that's cool. Nice bunch of people. Um, Right, yeah, let's get into it. So yeah, I've seen some questions coming in already, but we'll get into the ones that have come for the week first. So let me just put this. Oh, that's a long old link. Hold on. Let's see if it fits into YouTube. It's not going to. Um, I might just I'll try and work out. It's yeah, YouTube's not letting me do a link that big, unfortunately. Ali, there's a question. Yeah, raise a question this week. So I've seen you've answered it in the Facebook group, so I'm not going to add to that. I think the answers you got from the Facebook group were pretty well. As I say, I've got nothing else to say there, so hopefully that will be a good source of information for you. Share the screen. Here we go. So, question one for tonight is the following. If somebody is going through a review after prevention duty comes to an end, on the basis this duty has come to an end because, so they're quoting here, you've been offered placement in our support accommodation. However, support accommodation is closing down due to local authority cuts in a month. An assessment of medical needs not acknowledged on PHP properly assessed, properly or even assessed. All they've done is to try to put that person down private rented scheme instead of assessing their needs correctly whilst in support accommodation. What's the best thing to do here? To give a bit more insight, the application was submitted on the basis of fleeing gang violence. Housing officer contacted police regarding FOV. I might figure that out in a minute. However, due to the case being closed, as there was no CCTV footage, she didn't believe fear of violence claim, as in, I think the housing officer didn't believe the fear of violence claim, got put into support accommodation on discretionary basis, and prevention duty has come to an end. So, okay. I'm a little bit, so we'll try best to make sense of this because it depends what we mean here by supported accommodation, I think. So someone's made a homeless application, as in they would class as being threatened with homelessness. Now, if there's allegations or claims of sort of threats to safety, stuff like that, then I'm not sure the prevention duty should have kicked in anyway. It should have been the relief duty, but hey ho. But then the council's then offered a place in supported accommodation, and if it's traditional type of a supported accommodation, then what that essentially means is that person's no longer homeless in ordinary circumstances, and so the prevention duty would be closed. However, you've then got this issue that the supported accommodation is closing down in a month. I guess that's going to be like sort of April 5th or something. It's going to close down, and what's sort of that's yeah, it's less than 2 months away, less than 56 days away. So yeah, doesn't it sounds wrong to me. Um, if I'm reading that right, it shouldn't have happened that way. But yeah, I mean, ordinarily they can close the prevention duty down if someone basically secures accommodation that's likely to be available for 6 months, which generally speaking, support accommodation would be. I don't. I'm maybe speculating here that the council is not aware that it's closing down or something like that, or they're just being. I don't know. They're just putting people in there just because they know there's a spare bed or something, and they'll pick it up later or something. I'm not quite sure. Either of you guys got a bit more of an idea on this than me in terms of making sense of it?
Do
Um,
you want me to go? Sorry.
yeah, I mean, I just know
I'm
if,
not
if you
real.
can kind of maybe eke out what might be going on here.
So the supported accommodation might be, I'm trying to go in order. So it looks like they never really accepted a proper duty or did a proper assessment. So you can review or ask for a review of all of that. Um, just because this lack of CCTV evidence, that doesn't mean that the threat doesn't exist. It means they haven't done a proper assessment. So the council's conduct there, if your accommodation's closing down, you're at risk of threatened with homelessness there. So they need to be processing your application properly, doing a proper housing assessment, doing a proper housing plan, looking at your medical needs. And I think you'd be better off with a solicitor here. But you can ask for a review of the decision if you've got a final decision, and ask them to make a fresh homeless application.
Yeah, I
That
think I
suit me.
think basic. I think whatever happens, make a fresh homes application because this person is once again threatened with homelessness because of the supported accommodation essentially coming to an end. Uh, in terms of the issue about the kind of level of evidence and the kind of fear of violence and stuff, it's a real difficult one on this ground because usually with things like domestic abuse, the threshold for evidence is much lower. But when it comes to evidencing kind of gang violence, that sort of thing, then it doesn't say it specifically, but in effect, there's a higher threshold of the level of evidence required. Now, what I probably would say is that it sounds as though this person would have given the council reason to believe that there might be some issues of abuse going on here. In effect, it might be effectively warrant a safeguarding a referral, an adult safeguarding referral. which again, that would be a low threshold, and that would then lead to potentially a bit more of assessment and stuff like that. Probably wouldn't, unless, it probably wouldn't result in any kind of like actual support from social services, unless there are some care and support needs here, which aren't mentioned. So, although there is something about, what's it say about priority need? I thought it did mention something about priority need. No, maybe not. Maybe I'm getting confused. But yeah, yeah, no, sorry, assessment of medical needs not acknowledged. So it's possible there are some care and support needs there. Therefore, a safeguarding alert might be more likely to actually result in a kind of more in-depth assessment. But that would be probably how I'd maybe like play it. But again, I think in this situation, it might be just easier to start again, make the homeless application whilst the person's in supported accommodation, because they're going to have to leave at the end of well, the beginning of April or whatever, and then see what happens with that. And I guess the prevention duty should initially kick in, because they're, again, they should be looking to find alternative accommodation that's going to be suitable for them before that time period ends. It gets really interesting with priority need during the relief and prevention duty, because essentially, if you're in priority need, they have to provide you a higher level of, higher quality of accommodation at the end of it. But you ordinarily, housing officers won't actually be looking into it at all. It's just I think it's basically almost like an artifact of some previous version of the code of guidance or something. But yeah, I think make the application. There's a video on the channel called "The Best Way to Make a Homes Application," and just follow the steps in that, which basically involve making sure you're including the kind of the relevant information, potentially contacting local councillors, that sort of thing, to help you out, as well as a few other bits and pieces as well. So I think just follow those steps and keep it really methodical, because yeah, I'm not quite sure if this most recent support that the council's offered is lawful, but I don't know what you gain by kind of going back and getting that sorted out at this point. The most important thing here is that there is going to be further accommodation after the end of this supported accommodation placement. So
There is
yeah,
the threat of fear of violence. So there is case law that the word likely means, what is it, real and serious possibility. So that's the case law, but then they have the code of guidance that the term should be interpreted like broadly, and they have the serious violence strategy, which is the threshold, and that's kind of means violence doesn't have to meet that threshold. So it's just kind of like that equivalent to violent behaviour, and like the threatening or intimidating behaviour may be held as violent. So it's kind of like it's in on a case by case basis and what you can argue, I suppose.
yeah.
Does that help?
Yeah, I think that's what the law is. I think the housing officers are unlikely to really kind of. It becomes quite easy for housing officers to brush it off. So
Yeah.
unless there's like more evidence, or like me, or maybe the national referral mechanism's been engaged or something like that, that's when it might become more useful. But I just
Yeah.
think without that kind of level of evidence, unfortunately, housing officers can just kind of like just leave it really.
Or you can request your information from the police that investigated, and you can hold that as evidence. So
Yeah,
like a SARS request.
yeah.
I guess that
Um,
matters if they don't have local connection to the area. Because where it said like supported accommodation on a discretion basis, I kind of wonder if they were needing to not have local connection by the fact that they were at risk of violence and abuse, um, which is potentially why it's worth bringing up again in their next application. But even then, you could bring it up at a later stage, couldn't you? And like bring it up for local connection rather than for priority need.
yeah. Uh, I've not had a lot of luck kind of helping people out in this kind of situation before, if I'm honest. So forgive me for not sounding terribly optimistic about the prospects. But I mean, yeah, I think all of these things we just said are kind of valid things. I just think it's one of those things where it's just very, very difficult to actually get the council to follow the law. So yeah, I think potentially the adult safeguarding route might kind of give a bit more of a kind of a policy lead on what the council officer should do, because yeah, I don't know what other kind of leverage you've got really. But so yeah, I'm sorry not being very helpful. I also just had to delete a bunch of messages because they're in the first person. So I have now identified the question they're talking about. So just leave it, and I will. Um, yeah, I'm just doing that now. So I'm just deleting it now. So yeah, cool. Hey, you right, Tiff? You don't need to apologise for being late. You right, Cheeseface? Um, Yeah, cool. I'm just keeping an eye on the chat, guys. Sorry about that. So yeah, right, my head's back in it. Right. So I don't think we would. Oh, well, I don't feel I was terribly helpful there. But I think, yeah, make the application, take into account the kind of things we mentioned, and effectively hope for the best. I think that's about as good as I can say at this point. So yeah, cool. Question two. I have a question about how to assist a homeless individual with a history of arson-related behaviour. For instance, a client was evicted from supported housing after attempting to set themselves on fire in their accommodation. They approached the local authorities' housing options department as advised, and the social worker has been unable to secure alternative housing. Due to the perceived risk, the housing options team has ruled out placing them in temporary accommodation like hotels or B&Bs. Additionally, supported accommodations are unwilling to take them in. What options are available for this individual, especially if a relief duty has already been initiated? To provide further context, they also applied under Part 6 but were disqualified due to unacceptable behaviour. So I guess the first question I would have about this is about priority need. So there's a mention of a social worker here, so presumably there's some care and support needs or something. Obviously, there's a fact they just tried to set themselves on fire. That's going to probably be an indicator that they are having a rough time, to say the least. So priority need here is going to be really important, because priority need is going to be the thing which basically makes or puts the council under a duty to provide suitable accommodation. And there is nothing in the law which says councils have to house people unless they've got a conviction of arson, or unless they've kind of got risks of arson. Councils, the duties councils owe apply to people who with arson convictions or arson histories, whatever, just as much as they do to those who don't. So essentially, what you want to do here is uh, get the council to accept the person's in priority. So that might be about kind of providing evidence from whatever evidence is available in terms of medical issues, mental health issues, risk of being exploited, essentially kind of, whatever might be relevant to that decision, and get the council to accept that they're in priority need, or that they might be in priority needs. If they're going to put in writing, for example, that we accept there is a duty to provide interim accommodation, but we won't do it because it's too high risk, that's essentially going to be an unlawful discharge of their duty. They have a ongoing duty, or should I say, a longer term duty to carry out a homelessness strategy every 5 years, where they're supposed to identify the types of accommodation they need, and they should identify that people with arson histories will be turning up at their door and asking their help, asking for the help at various times. And so this should not come as a surprise to them. It's not okay just to say, oh, we don't have anything. They are under a duty to make sure they do have some sort of suitable option. So I mentioned this before in the live stream. So in Bedford, there's an approved premises with quite a few females who've just kind of come out of prison. Quite a few of them I've worked with have got arson, very serious arson convictions, and not just kind of trying to set themselves on fire, like actively trying to set other people on fire, and or actually setting people on fire. Um, and the council's duties were absolute. The council basically had to find private landlords who were willing to take those people. That was the way that they had to do it. So yeah, I think essentially you almost kind of, my first answer is going to be evidence that they're, find the evidence that they're in priority need and get the council to accept that. Once the council's accepted they're in priority need, that's them accepting that there is a duty to house them, even in the short term. And then basically, I mean, yeah, if you can't get a solicitor involved, complain loudly about the fact the council's not basically discharging its duties lawfully. There would probably, I mean, I'm assuming the incident there is what led that person to become homeless. So as in they were in supported accommodation, then they tried to set fire to themselves, and now they're not. So there is also going to have to be an argument at some point about intentional homelessness. And again, it's going to depend on the situation in the, what happened. If that incident was related to that person's mental capacity or mental health issues, or they're really intoxicated or something, then check out 9.17 of the Homelessness Code of Guidance to have a look at what kinds of things can, or essentially should not be regarded as being deliberate acts. So those things might kind of be useful. But yeah, I think that's my answer anyway. So first of all, look at priority needs, then have the argument with the council about the fact that they have a duty to house them, therefore they need to do it, and then have the argument about intentional homelessness. Shannon or Karis, you got anything to add to that? Shannon?
Yeah, and I'm not an expert in this at all, but my understanding of arson is that it has to be property. So and obviously it says arson related behaviour, and we don't know the whole history of this, so there might have been other instances where they did light stuff to fire. But the definition of arson, I believe, is like deliberately setting fire to property, and a person isn't property. And so I would assume there was some mental health stuff going on if a person has set themselves on fire. I would, again, this is assumptions, but I'd assume that was like a suicide attempt. And so I'd actually I'd be sort of, and again, depending on previous stuff that's gone on with this client, I would be rewording it and not calling it arson, but suicide attempt. I'd be making it really obvious that this person had a disability under the Equality Act, and they could be actually discriminating against them by not housing them, and by sort of, social landlords and stuff not doing that, and just everything as well as everything else you've said. That's sort of the main thing, not the main thing, but apart from the stuff you've said, sort of taken from that. But obviously there might have been incidents of arson as well.
So
But yeah,
I'm
if
just
someone,
googling. I'm just googling it. So yeah, so although yeah, it looks like you're right. So arson is technically when you set property on fire. However, there's this. I'm just kind of come across this term self-immolation. But I think whether or not it's technically arson or not, any landlord or any provider of accommodation is obviously going to be very wary. I mean, yeah, in one sense, it's not unreasonable to not want to take someone on who basically presents an identified risk of setting fire to themselves.
100%.
And
Is it something though that has to be declared? Because I know, like, look, it's perhaps a slightly uncomfortable situation or topic, but actually some sexual crime offences, they don't have to be declared in all situations. Now, I'm not saying don't declare it to the housing officer, but in regards to like landlords, estate agents, etc., sometimes they don't have to be declared. And it would depend on sort of the conviction and stuff. And I don't know if this person has a conviction, but again, I'm just wondering if, yeah,
yeah, I don't. I mean, yeah, there is no mention of a conviction here, and it doesn't sound like
no,
that's necessarily going to happen. But I think again, like a council, it's got what's it called, a duty of candor, or if that's the right word for it, but kind of it can't sort of give. I mean, I guess the worst case scenario is they refer someone to a different landlord. That person proceeds to kind of set fire to something again that ends up in a loss of life or something.
yeah.
The council is not going to have a leg to stand on there, even if it's kind of legally or morally or whatever. They can't do it. So I think they need to have something else. As I say, this is why they should have picked up on this issue within the homelessness strategy, because it's not easy to find housing for people who present a risk of fire to other people. However you
And
want to kind of term it.
hopefully a decent care assessment, like you were saying, sort of also really highlights actually what are the risks, what aren't the risks, what's the history here, what's the future
Yeah,
sort of look like for this person. Yeah.
yeah. I
And
mean,
they should
because
be developing like a risk management plan for their suitable housing options. And like you say, make reasonable adjustments in terms of where they're going, and a multi-agency approach should be done here with a mental health team and
yeah,
community support.
yeah. Because I think I mean. I think the general question about arson is you need to always look at that kind of the facts of the case, because if you've got somebody who set fire to a bin when they were 15 or something and they got an arson conviction, that's true, and now they're 50, well, that's a low risk. But I think for someone who's literally just see it clearly in a bad way, um, it's difficult. And again, the question of, I guess, mental health services maybe should be maybe would be entitled to carry out a capacity assessment as well about what's happened there. And I'd expect someone who's just tried to set fire to themselves should probably be in hospital, to be honest. No mention of it here, I guess, but yeah. So I don't know. Again, I'm hoping within what we've just said there'll be some stuff that this person can kind of take away from it, but it's not an easy situation. But I think just kind of show focus on showing that the council does have a duty to provide suitable housing for them, and then kind of see what happens next, and kind of just keep pushing for it. So yeah. um Question 3. So hopefully we can be a bit more definitive about this one. So yeah, so totally unrelated, as into the video that this was commented on, but I wanted to know if there's been cases of council stepping in as guarantor. Obviously, a personalised housing plan makes it mandatory for the client to look for private accommodation, but in today's market, it's next to impossible to find anything without guarantor if one is in receipt of benefits. So, yeah, so I'm not aware of councils acting as guarantor ever, because acting as guarantor, I think you're actually basically risking a huge amount of money should that person kind of mess something up or, kind of, I don't know, trash the property or something. So councils, I think pretty much every council has got like a rent deposit scheme or rent bond scheme or something that they're going to have, which basically means they'll guarantee the deposit, which will be whatever, the 1 month's rent or something. So that's fairly common. But yeah, obviously lots of landlords won't accept that. But I've never seen a council consider being a guarantor because of just how onerous that arrangement can be. So I think the answer is no. As I say, I'm pretty sure it is, unless Karis or Shannon know differently from me. I think that's just, yeah, okay. I think
This,
we're
yeah,
go.
it'd be okay. Sorry, it'd be a case of talking to your council and see what their policy is
Yeah,
and what they can do to help. So your specific council that you're approaching, that you're in, borough.
yeah, yeah, cool. Um, okay. So next one here mentions a pet dragon. Okay. I haven't read these before, by the way, so see what this one says. Someone got Section 21. Housing officer did literally nothing in prevention stage other than talk to the landlord after tenant already negotiated 2 more months. Then sent the personalised housing plan, which wasn't discussed with the client, and a link to an agency which seems to be a dodgy one. Email subject was relief before previous eviction date. The worry now is that the housing officer likely just sits back until relief duty is done, then discharges. The client is gathering medical letters to support priority need. Based on what the housing officer knows, client would fit priority need due to severe mental health issues, but it seems all a bit hopeless, really. Since the landlord already said he wants to go ahead with the eviction, it means it's unreasonable to stay after the 2 month extension has expired. So technically, the council has to provide interim accommodation, right, and protect all the belongings, including the pet dragon. I think is this the iguana question again? Um, so what are the chances of winning this fight? Well, with a solicitor, then the chances are pretty high. Because essentially, I mean, yeah, there's no kind of golden ticket for vulnerability and priority need, but severe mental health issues are, a pretty good a good shot at it. So yeah, I mean, basically, once this agreed 2 month extension expires, then yeah, I would say just based on these facts here, there would be a duty for the council to provide interim accommodation because assuming that kind of we're taking severe mental health issues to kind of mean what we usually think it means, that is definitely going to be reasons to believe that person might be in priority need. So you're going to have somebody who might be homeless. We're assuming here that they're eligible for assistance in terms of having recourse, and the severe mental health issues are reasons to believe they might be in priority need. So yes, the interim accommodation should be triggered at that point. And that would also basically, well, in fact, the as soon as the person is homeless or is homeless, as soon as the relief duty kicks in, let's put it like that, there will be a duty to protect belongings. In fact, either the relief duty or Section 108, either of those kick in, there'll be a duty to protect the belongings, including pets, potentially. I mean, probably. Again, it's a bit of an interesting one. I think if we're talking about a reptile, I think someone said in the chat a few weeks ago, probably best not to mention it, even if it is a 6 foot glass cabinet, if we're talking about that case. So, yeah, I think as well as getting your medical evidence together, I would uh, pray that you've got a useful advocacy service local to you that you can get some support with it. The problem is with solicitors, one of the problems with solicitors is, first of all, they're massively kind of over capacity. Second is I don't think they can't really kick in until the council's actually done something wrong, which you don't really want to have to wait for the council to get this wrong. You want to actually go in and get the argument right first of all. So with priority needs through vulnerability, through things like mental health issues, effectively what you need to try and get is medical evidence which basically explains what's likely to happen to this person should they become homeless, because that's the test. If you don't ask for that information, the council probably won't ask for that information because they tend to just ask for a patient summary or something useless like that. So you want to focus in on getting supporting professionals to essentially give their opinion about what happens to this person should they become homeless. And yeah, in all likelihood, their mental health issues, their existing mental health issues, are likely to get even worse should they become homeless. That is likely to pass the test of vulnerability. So I think that's kind of, yeah, yeah. Um, that's what the law says. What the housing officer actually goes and does is a different thing. So, I mean, Karis, am I right about the kind of solicitor thing and actually having to kind of have something from the council which is kind of breaking the law before a solicitor can jump in, yeah?
Not necessarily. I mean, we can assess a place and then work alongside and sit there and say, we're aware of this case. What are you doing? What's your assessment here? And if they fail to act, we're then turned straight in. So we don't necessarily have to be there when it's gone wrong, if that makes
Okay.
sense.
Yeah.
We can still
Uh,
be in there because you're at threat of homelessness. So we're involved in the homelessness application under legal aid. So we can still be there even if they do nothing wrong, and then we just sit there and go, okay, we'll close your case now.
And I guess that's going to lead to the obvious question of, is Virgo solicitors, or does Virgo solicitor have capacity at the moment, or is it at breaking point?
I mean, hopefully none of the support staff watch this. But yeah, I think we've got capacity for it. Yeah, I would say yes.
Okay.
And Will's
So
not here, so I'll say
yeah. Yeah. So okay, well, which case this person might be well worth contacting Virgos and maybe asking for Karis, if that's all right for me to say that, Karis,
yeah.
and just kind of just to run the situation by them. Just maybe that would enable Karis to kind of get more of an idea of what's going on, get an idea of what medical evidence there is, and kind of go from there. So yeah, cool. Thanks, Karis. Next question is an interesting one. I think it's a fairly short answer again, because I think the answer is no. So if you use a person to help us and they charge for their advice and time, can this be claimed back via the LGO? My answer is I've never heard of that happening before. However, I don't think it's completely wild to ask for that. Should a complaint be upheld? And then because essentially you get an element of the compensation will be for the time and trouble to raise the complaint. And so, which is usually like a couple of £100 or something, so it's not a lot. But yeah, I think it's a plausible thing to ask for. I think it's a reasonable thing to ask for, but I've just never seen a LGO decision mention that before in terms of basically paying for some kind of support service to do it. So I think the only answer is, well, the best answer might be to ring up the LGO and just ask that question, because you can ring them up as far as I know. I'm going to check that as well. Certainly they used to have a very helpful advice line. I'm not sure if they still do. Let's have a little look. They probably have all gone sort of like, yeah, kind of automated and stuff. Let me have a look if there's a number still. Contact us. Telephone. No, there is still a telephone number. Talk to a complaints advisor. Yeah. Okay. So here, well, I'll put the number into the live chat anyway. Here it is. So that's the LGO's advice line. Just give them a call. It'd be interesting to know if you find an answer from them. Like, if you get back to us and let us know, because that's a good question to ask. Cool. Next question. So. Yeah, well, okay. So this question here, actually, I can't find it now, but I just wanted to ask it anyway. So I think basically someone deleted the question. Essentially, the question was, if someone's Irish and has been living in Ireland, and is made homeless in Ireland, can they come to England and claim benefits and essentially make a homeless application here? I actually think they might be able to. Ireland's part of the common travel area, which I think basically means people can move around freely. Shannon, I'm looking at you because you're a bit Irish. So do you know if people can basically come to the country and, yeah, claim benefits and approach for assistance, or is it not quite that simple?
I don't think it's that simple now we've left the
Oh,
European Union.
right, okay.
So even though it's a common travel area, that's for like traveling, not my understanding anyway. And I'm not, even though I'm a little bit Irish, I'm not an expert in it. And obviously there's differences between Northern Ireland and Southern Ireland. I nearly said proper
Yeah,
Ireland, then that's bad. But I don't think necessarily, and I think it depends on things as well. Like, do you pass the habitual residency test? How long, your intentions and everything else. But I don't know if you could do it on a whim and get the same things. I think it would also depend on what you were entitled to in Ireland and what your circumstances were there, and how transferable that would be over here. And if you've got like dual passport, which lots of people have, like a British and Irish passport.
All right.
okay.
So not very helpful. Go on, Karis.
Yeah, I've recently had an Irish citizen, so they were eligible for benefits and an Irish passport and social housing. because there's a commitment between the governments.
Yeah, I think it might supersede the whole Brexit EU thing. I mean, so obviously Northern Ireland would be a definite yes. Um, uh, yeah, in fact, I'm not. To be honest, I'm not even sure how local connection works. I'm pretty sure local connection stuff only kicks in within England. So, for example, you can approach Scotland, like a local authority in Scotland, and I don't think the same rules apply in terms of how local connection works. Let's stick a pin in that question because the AI thing on is telling me that the people can, and Karis has said they can. I guess I want to get to the bottom of whether anything's changed with Brexit. So
Yeah, because he had
I
an
might.
Irish passport, my previous client.
And had he been living in England for any length of time?
Yeah, and working over here.
Okay.
So I think
Worked
if
in
you've got a
Japan.
passport, it makes a big difference. But I know it's not easy to get an Irish passport currently because the long when I last looked, I think the Irish government was like it's like a 3 year wait, and X amount of money to get it because there was such an influx in applications. Because once you get that dual passport, you open up a lot of opportunities because of the EU stuff with Ireland.
All right.
Okay, cool. Um, right, so that is the end. That's the last of the anonymized questions that came through the week. There is one more we'll do, which is not anonymized, but so we go to the live chat now. So, what if someone is currently in temporary accommodation out of area? Let's put it in here. So, yeah, what if someone is currently in temporary accommodation out of area after becoming homeless? Can they lose local connection while bidding for original borough? So, no, they can't. But interesting, they can also get local connection in the borough they're kind of been placed in. So it didn't used to be the case, I think, but now you can get local connection for essentially, yeah, the borough you're also, or the district you're also living in. But no, you can still bid on your original borough's. It's your original council that has the duty to you. So if you're owed the main duty, for example, yes, you might be housed in temporary accommodation in another district, but you would continue to be able to bid on properties on your own council, as in the first council's housing register. So yeah, I think this person would be all right in that situation if that makes sense. Um, so yeah, unless Shannon want to add, I'm hoping that's pretty definitive, but unless anyone wants to add anything to that, we'll go to the next one, which is, oh, it might be all the questions. Some few comments in there, which is nice and helpful. Thanks, Stella. Thanks, Cheeseface. There's okay, a question here. So about local connection again, actually. So yeah, local councils, including Bournemouth, Christchurch, and Poole Council, are expected to adhere to the national guidance when determining local connection criteria and procedures. Which takes precedence? Is the law to state this? So in one sense, there are two definitions of local connection for every area. But which one gets applied to you depend on your own circumstances. So if you're homeless, you'll have the Part 7, the homelessness definition of local connection applied to you, which is in almost all cases much more relaxed than the Part 6 definition, which is what Bournemouth, Christchurch, and Poole will have themselves. They'll have a policy. If you Google Bournemouth, Christchurch, and Poole's housing allocation scheme, there'll be a different kind of definition of local connection. We've said many times before it's ridiculously confusing calling both definitions local connection but meaning two different things, but that's just the way it works. So say for example you're not homeless and you apply to Bournemouth for social housing, you will have the Bournemouth, Christchurch and Poole definition applied to you, which I expect is going to be at least sort of 2 or 3 years. I don't know exactly how much it is. Whereas if you were homeless and you approached Bournemouth, Christchurch, and Poole, then you have the Part 7 definition of local connection applied to you, which is basically 6 out of the last 12 months. Or if you're rough sleeping, essentially you just need to be there. Family connection, stuff like that. So it's not that one kind of trumps the other. It just depends on your own circumstance. The problem, or one of the many problems, is housing officers often misapply it. So they'll basically judge you if you're homeless, but they'll judge you against the non-homeless definition, if that makes sense, which is almost always going to be stricter. And so they'll say, oh, you haven't lived here for 2 years, so you can't actually make an application to us. But if you're homeless, you absolutely can. So yeah, so there's not, yeah, that's kind of the way it works. It's not that one kind of trumps the other. It's just that there are two, depending on your own circumstance, will define which definition you get judged against. So just got some stuff coming on the chat. So Andrew saying, so UK and Irish can move both ways and access social housing and benefits. Lots of Brits move to Southern Ireland as the benefits are much higher, but there are virtually no social housing in Ireland, so it's not all milk and honey. Yeah, it's nicer there, though, isn't it? I've never actually been yet, but yeah, yeah, okay. So yeah, I think so there's no mention here about this. It doesn't seem that the habitual residency test is going to be relevant here. I'm fascinated to how it actually works in practice, and kind of whether someone coming from Ireland can effectively approach anywhere. Does local connection even kick in? I think these are questions I need to go and do a bit of reading about to find out how it works. So yeah, but thanks for that, Andrew. Right, if yeah, this is so here we go. So question 8. If you made a housing application before making a homes application, which is pretty common, that often happens, is it normal to get sent a link again to apply again? No confirmation the original register has been received. So yes, it is, and that could easily be just because of just base level incompetency with the council. So it's not uncommon at all to have to send documents multiple times, kind of complete forms multiple times, that sort of thing. So my guess is the first housing register application that was made would go onto the automated system and probably just kind of sits in limbo for a while. But then if someone then makes a homeless application, it's probably more likely to be dealt with a human being who might just basically disregard what's happened before, send out a new form, get the person to provide new information. That's probably not a bad idea to do anyway for a housing officer. So I don't think there's anything to be kind of worried about there. And also, effectively, if the homeless application is successful in the sense that you get owed the main duty, that will reset your housing register application anyway. So even if you had been registered, even if you had been banded, so you made a Part 6 application, you got band C or whatever it might be, or band B or something, let's say, and then you make a homeless application and you're still at band B because that's how that particular policy works. Every area is different. Then your banding date would basically be the new date. Yeah, I don't think some check the small print of the council because I have seen some policies that basically in certain situations would allow you to keep your original date, but generally if you're moving up a band as and you're getting more priority, you'll be given a new start date for that banding, if that makes sense. So yeah, so I think basically if you made a Part 6 application but you're now homeless, there's not a lot to gain really by kind of going back to the Part 6 kind of application process. Just basically start again as homeless and just fill in that form or fill in all forms, provide all the information, and hopefully you'll get processed pretty quickly and be owed the main duty. Cool. So number 9. If someone was in receipt of benefits and isn't in receipt of ESA benefit any longer, are council supposed to still pay housing benefit and not kick vulnerable tenants out? So, okay, it gets rather confusing because obviously everything used to be housing benefit, then universal credit came in. Universal credit, as far as I'm pretty sure it's rolled out everywhere now. There's no sort of areas. No, it's really okay. Wow, is there how many areas are not still not caught
It's
up?
it's not areas, it's claimant types.
Okay,
So there's lots and lots of people on ESA and housing benefits and forgive my brain melt, but that old age benefit, whatever
pension
that one
credit?
was. Yeah, I
No.
think so, yeah. So those I think are the 3 groups claimants still left to transfer over to UC. And it's a lot of people, like hundreds of
Okay,
thousands of people still left to move over.
really? Okay, so. But then, so this person's not receiving ESA benefit any longer. So presumably, if they would essentially, if they need their rent topping up or whatever, let's say, I mean, I'm not sure if they're just claiming universal credit or if they have got some kind of maybe part-time work or something and they can't afford their rent. Then I don't know. I'm not trying to work out how this would work, how this would arise.
So
Because
it should get transferred over to universal credit and the housing benefit should get transferred over to housing element. There also should be a period of transitional protection for the claimant where they have a period where they don't get any less money. So like they're protected, so they're not going to lose any money. And that would apply to the housing element as well. And that transfer over. So it's probably complicated in terms of like getting the council to realise that there's a changeover And if the housing benefit was being paid direct to landlord, which again, a lot of the times housing benefit is paid direct to landlord, you can still set that up with housing element. And again, you just like explain that you were on ESA previously, and there's a long list of people who are eligible for it, and it's quite extensive actually. Shouldn't be a problem for them to pay it straight to the landlord, so there shouldn't be any reason for vulnerable people to be kicked out. Yeah, citizens' advice are quite hot on this at the moment. They've got quite a lot of good advice around the move to UC. But also there is a dedicated helpline for people who are moving to UC or have moved to USC, and there's particularly like workers and schemes around people on ESA because they are a particularly vulnerable claimant group. So yeah, I would definitely reach out to the DWP and the move to UC sort of helpline and stuff because they should be able to help iron out anything. And CAB, like your local citizens' advice.
Cool. Thanks, Ren. That's helpful. Nice one.
Do you want me to just add the not kick a vulnerable tenant out?
Yeah, go for it.
Sorry. So the social landlords and council tenants have that pre-action protocol that they have to address if there's been a benefit area. So they have to go through a process before they can't just come along and kick you out and change the locks or anything. So they have to go through a pre-action protocol before it even steps into court that they'll look into your benefits and they'll try and help you out here. So it might even be worth talking to the council's housing benefit department there and saying there is an issue with your benefits. So then you've done your part in informing them that there's a change in circumstance.
And I guess if your income drops significantly and you effectively can't afford it, then you might actually be homeless. So at that point, this is an interesting point, where a good example of where if you rang up a housing benefit department and said, look, this is my situation, my benefits have dropped by 50 or £100 a month. Can you help me out with housing? Can you help me out with this? Something like that. That would actually trigger a homeless application. Now, I imagine the vast majority of housing benefit advisors have never been trained on that, but that's how it should work. This is a good example of how the idea is you can approach any department of a local authority and ask for help with housing any way you want to. That would trigger this kind of this approach. But as I say, most councils probably don't follow the law in that way. So, but if the income has dropped significantly and this person is then struggling, then they should also make a homeless application. And basically, again, it's not going to do any harm. And basically, just based on the fact that this person can't afford their rent now. So that would be how, and they would not be found intentionally homeless if they then were evicted. So yeah.
So put it in an email to the department and ask them about a discretionary housing payment as well.
Yeah. So yeah. I mean, it's probably not a bad idea to kind of, and just use language like homeless application. If you're just being really polite, you just might say like, can I make a homeless application in this situation? My income has just dropped and I can't afford my rent and I need some help with housing from you guys. That would essentially trigger a homeless application without putting anyone's nose out of joint. So yeah, cool. Thanks, Karis. Oh, I don't know this one. I don't think you can. Hold on. Let's get it up. How does someone get on both housing registers? Will they accept applicant in temporary accommodation through a different borough? So I think what this means is, can someone apply to two different councils' housing register at the same time? The policies I've read, and I've obviously not read all of them because there's hundreds of them. The policies I've read, they'll basically specify that if you've applied to, or if you're on one housing register in one district, you can't apply for another borough. But there might be some exceptions to that. I don't know. So it may be possible in some areas. I think you'd have to just Google the councils or both councils' housing allocation schemes, which is the main policy which dictates how they allocate social housing, and just basically look through the small print there to see if it says anything about whether people can apply for two places at once. Homeless applications, you can make simultaneous applications to two different councils. But generally speaking, if you do that, your application will end up being progressed with one or the other. And you have to declare that you're doing it. So you can't just kind of do it secretly and not tell the other council that you've applied to two councils. You have to tell them, I've applied to this other council as well. Now, both councils would potentially have duties to that person. But in terms of Part 6, it might be again something for me to have a little look at around this, but I don't think most councils are essentially allow you to do it. As in, you can always apply, but you're not getting in trouble for applying. but they're just basically, as soon as they realise you're registered somewhere else, they'll say no. That will be my guess. Cool. And then just Tiff's just saying, yeah, some vulnerable people are allowed to stay on legacy benefits if DWPs agree it's in their best interest. Do you have a link to who's allowed to stay on legacy benefits, please?
So again, like, I'm not a benefit expert, but my understanding from like my conversations with the DWP is no one is going to be allowed to stay on legacy benefits. Like, everyone will be moved. But like I sort of mentioned before, there's the enhanced support journey, um, which is for particularly vulnerable people who don't want to move or are scared of moving or have particularly complex cases or have been on ESA for a very long time, or there's various other circumstances. But everyone will be moved over. Like, yeah, that's quite clear by them. So there's no list as to who's allowed to stay on. There's a list of, like, if you Google on the DWP's website, they're doing it in waves. So you're advised to not move to UC until you've had your letter asking you to move, because they're doing certain groups of claimants at certain times so they can focus their efforts and energies on one sort of cohort. But yeah, there's no list as far as I'm aware.
And generally speaking, are people worse off or better off when they transfer to universal credit? Let's say they are eligible for limited capability for work. Would they get more money or less? Or is it the same?
So they should get the same. If they shouldn't get less because of the transitional protection that's been put into place for these claimants. But actually a lot of people would be better off, because and for a lot of ESA claimants as well, they go direct to limited capability for work related activity. So there's no sort of like assessment period or 3-month wait or anything like that. Again, it depends on specific benefits the people are claiming and their circumstances. And the enhanced customer support journey is made up for these people, and it's the DWP, so they're not going to advise you wrong. Like, it's them doing and sorting and organising your claim.
Cool. Okay. Nice one. I don't know if I fully understand this next question, but we'll have a go at it. So question 12. If a council discharges duty and landlord court evicts you, can you be homeless in the borough you're currently in? Will they be successful and not intentional? Okay. I don't think I quite follow the question here. Can you be home? I mean, can you apply as homeless in the borough you're currently in? So I don't know if that's the question. You can apply to any council you want to, but it's pragmatically sensible only to apply to a council where you have a local connection to. I keep saying that. I've seen a few cases recently where you apply to the wrong council, so to speak, and they actually follow the law. They try to refer you back to your home area, and the other area just basically stonewalls the other council and basically gatekeeps you there, and the first council basically gives up and then just houses you anyway. So yeah, so I kind of always say, it's pragmatic to apply to your home area if assuming it's safe to do so. But it does actually seem that there is a bit of an argument to say if you really want to live somewhere else, actually applying there, as you're absolutely entitled to apply there, and it is possible that they will just not bother referring you back because it's just basically too much work. I know that sounds pretty crazy, and I think a lot of councils would basically refuse to do that. But always remember that the local connection is not like a duty thing. Councils don't have to refer you back. It's only kind of if they want to. And I think there was a case, I did a video about it about 6 months ago. I think it involved Runnymede, where one council basically tried to refer them back to Runnymede, or vice versa. Runnymede tried to refer someone back, and the other council basically took so long about it that they essentially gave up. I mean, the LGO upheld it in the end anyway, but by that point, the first council or the second council had basically accepted that duty. So, but yeah, I don't know. Yeah, I'm not sure. I don't know if I'm getting the right end of the stick with the question. I mean, if you're evicted through Section 21 and it's not your fault, then yeah, you won't be found intentionally homeless. It's basically gonna depend. It's gonna hinge on whether you're in priority need. That's the really important question when it comes to homeless applications. So, yeah, I don't know if that person wants to maybe clarify the question, or maybe just kind of focus in on something. But I that's the best guess of what that question might be about. In the meantime, there's this question coming here. So, If a client's been offered a council property but it isn't suitable, do you have any tips for them reviewing that property type? What's the process after accepting the flat? So yeah, so the textbook advice is always going to be accept the flat, then challenge the suitability of it. And there are going to be certain things which basically will be relevant to suitability. So things like affordability will definitely be suitable, will definitely be relevant. Things like if it's something obvious, like someone has a disability, like a wheelchair user, and it's up 3 flights of stairs, then you're going to win that argument. There's no doubt about that. When it comes to things like location, kind of schooling, kind of family connections, family support, that sort of thing, it gets a bit more difficult. And I think at that point you really need to get a solicitor involved, because there are a number of ways you can, a solicitor can have a good go at arguing with the council, and a lot of the arguments will basically depend on the council not having actually carried out an adequate assessment of whether the property is suitable. So that's actually, when you see a lot of these cases, the reason the council loses is they can't evidence that they took the right things into account. There will also be some councils that have a policy about how far away someone is placed. So I think Lambeth, for example, has a policy which says people won't be placed more than 30 minutes away from the boundary of Lambeth. So that came up with a case called XY v Lambeth, which was a really interesting case about this sort of thing. But I think, yeah, so I think there are certain things which definitely will be relevant. There's going to be certain things which definitely aren't relevant. So, what's kind of, what's regarded as wishes rather than needs. Now, councils they don't do a very good job of identifying when it is a need rather than a wish, but certainly kind of, things which are not related to support network, not related to disabilities, not related to schooling, probably much less likely to actually be successful. I mean, there are some really interesting cases where someone successfully argued. I mean, there's one case, I forget its name now, but basically where there was someone who'd been tortured in a prison with little round windows, and the flat they'd been placed in had little round windows, and it was basically sparking off their PTSD. They're able to evidence that with a psychiatrist, and that they actually won that suitability case. So it can be kind of quite unusual and kind of weird arguments you can make. Again, there's cases where someone's got vertigo, if that's right, not vertigo, acrophobia, fear of heights, and again, it's like, they had some kind of evidence of that somehow. Don't know how you get evidence of that. But yeah, they kind of showed that actually being put up on a 14th floor was just kind of undoable. It wasn't doable for them. So yeah, it's a really interesting question. It's a really good question. It's just very difficult to answer. Me and Will have been talking a long time about doing a video just about this kind of thing, suitability. I mean, I guess it's probably worth reading chapter 17 of the Homelessness Code of Guidance, which you can just Google, because chapter 17 is all about suitability of accommodation, and there's a lot of things in there which kind of goes into, kind of a bit of detail about what can be done. Karis?
All right, I was just going to go into consequences uh, after, not if you don't accept. That's where they could discharge their duty to you and find you intentionally homeless. So this is a criteria. It's always best to accept. Then if it's not suitable, challenge it afterwards. But rather than you being in the position now that they just discharge your duty, and if you're in a hotel, they'll stop saying you're booking and things like that. So the consequences of not accepting it need to be taken seriously. So from review, any tips for them for reviewing the property? Just find out what your needs are, go through your housing plan, that you've got everything on there and that it is, and Google where it is and the area before you visit it. And they only give you a certain amount of time to accept it, so just accept it and challenge it afterwards.
Yeah. I mean, in my experience, unless it's something clearly related to a disability, if it's social housing, it's probably going to be deemed to be suitable. It's on, yeah, I'm sure there are cases where it's not, but generally speaking, that would be how it would work. So yeah, again, I mean, it's not much help tonight, but I think at some point we will do an in-depth video about this sort of thing, and maybe look at a few cases where it's come up, because it has come up in a few cases in a very positive way recently, as in there was a good outcome for the applicant.
Yeah.
I'm going to call time on new questions from this point on, guys, because there's some questions coming in here. So no more new questions tonight.
If you want to go through the basics of the accepting the property, the flat, they'll go through the process after accepting. They'll go through your tenancy agreements. You have to sign that. and you'll meet with the manager and they'll hand you keys and stuff. But also bear in mind it's probably not furnished or have flooring. So you can approach. They should be helping. That should be in your housing assessment plan. But if you need any help with that, there's charities in your local boroughs that might help, and Citizens Advice can help you with like a hardship fund for white goods and furniture.
Yeah, cool. So yeah, I missed that bit. Yeah, that's helpful. Thanks, Karis. Tiff's just saying basically the one of the big issues we use universal credit is the fact you're paid in 5 weeks in arrears. So effectively you're going to be a couple of weeks without having to kind of get by, I guess. So right, okay, just going back to that previous question, I think there's a bit of clarification here. So let's put it in here. So just to clarify, council moved me to another borough to stay under TA. The council decide to move you again and refuse. Council decide to charge duty can, okay, it's not non-honours, but okay, can apply to the new borough I stay in. So yeah, you can, but okay, if you refuse an offer of accommodation, then you can be deemed to be intentionally homeless in a subsequent application. So you can. So let's say I applied to Bedford Borough. They housed me in Milton Keynes in temporary accommodation for a year. So I've then got local connections to Milton Keynes. I then refuse a final offer of accommodation of some type by Bedford without kind of a good reason or a good enough reason. I can then approach Milton Keynes. I can approach anywhere at that point, to be honest. But I can approach Milton Keynes. But they are likely to find me intentionally homeless unless I've got a good reason for rejecting the offer of accommodation. So that's again why it's, although when you reject an offer of accommodation, you can make a fresh application to the same council in theory, but they're likely to find you intentionally homeless. I mean, it does open up the possibility of having the argument with them again, maybe having a better go at it. But but yeah, you're likely to be found intentionally homeless. Yeah, so there's a bit more to this as well. I'm just going to try and follow it. Will I not be deemed not intentionally homeless from borough I apply to because I refused their offer? Yeah. So if there was a suitable offer made to you and you turn it down without good reason, that would be grounds to find you intentionally homeless in a subsequent application. You're not intentionally homeless at that point because it just doesn't work like that. You've got to make a fresh application and get a fresh decision. But yeah, just because you've rejected a different council's offer of accommodation, if it was suitable for you, then you would be intentionally homeless. It doesn't matter where you then go, you're going to still be kind of caught by that the way that works. Um, I think again, unless I missed something with those questions, I think that's what it's saying.
Is it worth just mentioning that you should mention it? Because if you withhold that information, it is directly relevant to your housing. So therefore you'd be knowingly misleading the council in order to get housed, and that's a criminal offence.
Yeah. So trying to play the game like that and thinking that you could basically not tell the other council. I mean, yeah. I mean, if they find out about it, whether or not they will actually bother prosecuting you, I don't know. But they're certainly going to get rid of you. It is a criminal offence to either knowingly tell lies or knowingly withhold information that's going to harm you, which this definitely would, uh, in order to try and get housed. So yeah, you
So
basically no way you're going to get away with that.
they've put a follow-up saying it's not final offer accommodation, it's another TA. It's unsuitable, but they deemed it suitable. So they've rejected TA offer that was unsuitable because they deemed it suitable, but obviously this person didn't.
Yeah. So basically, so it gets a little bit jargony, but basically the accommodation you're in between making an application and having a final decision made is called interim accommodation. Some people call it emergency accommodation. Once the final decision is made, let's say they accept there is a main duty at that point, you will then be in temporary accommodation. It might even be the same address you're in emergency accommodation sometimes, but it's now classed as temporary accommodation. You may then get moved down the line if circumstances change because the council need to move you or something. If you then reject an offer of temporary accommodation, because you're owed the main duty at that point, you would be essentially, again, without, if you haven't got a good reason for it, you would then be and yeah, that council would end their duty to you. They'd say, well, we've made suitable accommodation available to you. You've turned that down. We're then therefore going to end basically going to end all our duties to you. You can then make a fresh application to any council. but they like, as I say, same reason I said before, they're likely to find you intentionally homeless, and you need to declare that you're doing that if you're going to go to a different council. So yeah, that's kind of, I think yeah, maybe that's a better grasp of what the question actually was. So okay. So the questions that are asked after that bit are put in, guys, we're going to leave for tonight. I'm just trying to see if there's any things we can kind of deal with quickly. How long does it take to get a discretionary housing payment? Or essentially depends on the council, basically. Yeah, it will just depend on how efficient the council are. There's no kind of set time limit that they need to process or applications for it. But you can certainly chase it. It's not rude to ring them up every so often, every few days, really, just ask them for an update. So yeah, have I messed up? Have I lost question 13 there? No, I think we're all right. So the final question for tonight, as I say, there are some more questions in there, guys, but we've called time on out already. So the final question that came in through the week was this one here, which was not anonymized, which is why we're doing it last. So I was awarded main housing duty and I'm already in temporary accommodation. This might be the same situation actually. 3-bed flat, 6 months in, they're offering me temporary accommodation again somewhere else, really far and unsuitable. I've refused straight away with written explanation affecting my daily life. It makes no sense. Why are they offering me another place? So I mean, it won't make sense to you, but it would make sense in their heads, because it might be that they've got deals with landlords that are going on, and all sorts of things that will be happening. Not in any way there to promote your well-being. It's just to kind of save them a bit of money and just for their back office stuff. So it can seem very arbitrary when you're going through it. I refuse straight away with written explanation affecting my daily life. It makes no sense. Current accommodation is suitable and landlord has not mentioned wanting it back. It's been 6 months. Why is the council trying to ruin our life? I have kids at uni who's scared to go to this area. They told me 1 hour 20 minutes to work is manageable when I will take over 1 hour 30. Not taking to consideration my low income. So that's actually the employment thing is potentially a fair reason to refuse it, because I mean it's going to be kind of based on the information. So like for example, obviously the 1 hour 30 is presumably based on Google Maps or something, but you can absolutely kind of raise the fact of the cost of that, because if you're on a low income and you kind of live around from the corner from your work, and therefore it's not really costing you much to get to and from work, but then you're expected to drive or take a train or whatever for 1 hour 30, which is going to cost a lot of money over the course of a month, then that would be a very good reason to reject it. However, same thing as we said before, refusing it straight away is playing chicken. You're taking a big risk there, because if you lose the argument, then the council just wash their hands of you. So as unsuitable as that may be, I would highly recommend moving there, even if it's just in the short term. Put a review in as soon as possible. If it's temporary accommodation, if it's after the main duty's been accepted, which it has here, you can ask for a review of it under section 202, which doesn't require a solicitor. And that's essentially, and I think it sounds like the argument there that you really want to focus in on is the cost to get to and from work. I mean, it says kids in uni who are scared to go to this area. I guess it's, why are they scared? Is there been past incidents there? If there have been, then that might be relevant. So that would be how that would be kind of how you can argue it. But yeah, I think you need to understand, refusing an offer of accommodation, any accommodation straight away, there's a good chance that you're going to lose that argument, and then that's going to kind of make your life very, very difficult. So I'd say, although you might have written to them already and said you're definitely going to refuse, I would say, just kind of get back to them as soon as possible and say, actually, I've rethought it. I need to speak to you about it. I need to kind of reconsider this, but I will accept it in the short term, and then take it forward from there. So, yeah. Okay. So I think that's it, guys. As I say, there's a few more questions that have come in after that, after the limit there. Feel free to, I mean, I think it sounds like I'm just looking through them very quickly now. There's quite a few comments. I'm not sure how many questions are actually there, to be honest. There's a question there from Stella about why we do this stuff. So maybe that's a good question to come back to another time. Yeah, but the last question, so that question about where a tenant's died, very quickly. Let's just do it very quickly. I think we've got all the other ones in there. So yeah, last question for tonight is, what if you shared a private rented accommodation with someone who has died, and you can't afford it anymore? So you may well be legally homeless. because you can't afford the property, because effectively there was two incomes. We assume now there's only one income. And so what you should do is basically make a homeless application to your local council. And one of the things they can do is basically top up your rent in the short term. If it's social housing, then you would probably get the very highest banding when it comes to the banding, because essentially you're under occupying accommodation. And so sorry, it says private rented, doesn't it? So ignore that. Yeah. In the private rented sector, make a homeless application if you haven't got any other options. And as I say, in the short term, they might increase your income a little bit just to cover the shortfall, and then look at other options with you. So in this sort of situation, you may well legally be homeless. On the sound of it, it sounds like this person will be, and therefore make a homeless application to make use of the assistance that's available to you. So yeah, that's it, guys. Thanks for the questions. Sorry, it felt like quite a few of the questions there. We didn't give a very definitive answer sometimes, particularly those first few. I felt like they were kind of, maybe trying to find some more information about that this week. But yeah, as I say, keep going, keep bringing the questions in, guys, in the comments. Again, just to say, you're going to get a better response from us if you put a question into the comments on the videos in the week, so we can then kind of go through it in a bit more of a structured way. And also, you don't have a word limit on it, so you can kind of get your questions in. That's not to say we can't answer questions in live stream. It can be helpful just to kind of do it in real time. But other than that, guys, just keep doing what you're doing. Keep it methodical. Just kind of keep breaking down these big problems into smaller problems and just dealing with one at a time. We do regularly hear people coming back to us and saying actually they've had really good outcomes just by applying these basic bits and pieces, keeping it all in writing, essentially kind of just keeping calm, keeping methodical with it. You can start, hopefully you can get some good outcomes there. But appreciate this is all rather unpleasant stuff to be having to deal with, but hopefully this has been helpful tonight. And we will see you on Monday on Will's channel. And next, I'm going to make a decision on the spot. We basically next Thursday I'm not around, but we'll do the live stream next week on the Wednesday, which I appreciate might wrong foot a few people, but there's no other option really. So yeah, next Wednesday 7:30 p.m.